Hello, everyone. Welcome. Hello, everyone. Don't forget to type in your questions while we wait.
Bro,
We're live.
Perfect. So the time is I didn't check it. I don't. I think it would be fine because I mean, if you need a board, yeah, it's what you do. It'll be fine at this one. It should be fine. Tonight for sure it'll be fine. Yo,
Hey,
Hey.
I didn't get the invoice in my mail, so I figured I'd stop by
I was
and
about
see
to-
what's happening over here.
Are you joining us here?
Why not? Figured it's either I'm joining on YouTube or here.
That's true. That's good to have you. So, welcome to the live feed of the question and answer period. This is our second session. My name is Eddie Cara, and I graduated from GMSP in 2017, and then I did my certification at Université de Montreal in 2018. So let's see what our first question is. We also have people who are here in person. You're welcome to join us here. We're located on 1625 St. Catherine West. We are right next to Burger King and Tim Hortons, next to the MB building. So it's literally a 2-minute walk. Okay, so I'm also getting questions via my phone. Sad but true. Okay. So I'll try to coordinate with the people present here as well as the people who are sending in their questions. Okay. Keep in mind, spread the word because it's benefiting everybody who's in last minute need. So the first question I have here is from Emmanuel. He's asking, can you briefly summarize the Copyfax versus Lambert case? and why the injunction was granted. I'll just keep the title here. Okay. So, to start things off, Copyfax is a company that had photocopying machines in their client spaces. Similarly, Lambert tried to do the same. So he used Copyfax clients, meaning the stores, to put photocopying machines in as services that he provided. The first question you need to ask yourself is, what is an injunction? I think that's the thing that confuses the most people. So on the exam, if you're ever asked about an injunction, and you're asked what case it has to do with, this is the only case that you need to know in your file regarding injunctions. Would you happen to know what an injunction is? No? Okay. So an injunction based on your Chapter 4 material is basically a court order given out by the judge to stop breaching the contractual obligations. And in this chapter, well, in this jurisprudence, in this case, it was regarding a non-competition clause. Okay? And non-competition clauses, they're covered in Article 2089 of the Civil Code of Quebec, specifically the second paragraph of that article, that stipulates that even after a contract ceases to exist, meaning is terminated or resiliated by either party, you need to respect a reasonable amount of time and geography to limit your right to compete with your previous employer or contract, okay? And what is the reasonable period of time? As I've covered in my crashes and during the previous Q&A, it is, first of all, a lot of jurists will tell you it depends on a case-by-case basis, but it is between 6 to 12 months. I repeat, between 6 to 12 months. And according to jurisprudence, what is the reasonable amount of place in Quebec that you can limit someone's right to compete? I'm just going to fix the laptop here so that you can see me in much greater detail. So that is limited to the workplace. If you want greater detail, it's 4-kilometer radius from your workplace. And there's two reasons for this. Number one, a non-competition clause is given out by the employer to protect the business interests. And one of the business interests is proprietary information, like the client list, okay, that Lambert was using, okay? The other one is to have a reasonable amount of time so that you don't deprive an employee from their constitutional right to earn a living, a living wage, a salary, so on. So the questions asked in this case, is the non-competition clause in the contract between Copyfax and Lambert restrictive or abusive? Okay, so as I've said, these are the two grounds in which it has to be reasonable. They saw in the contract that time-wise, it was restricting Lambert of 14 months, and it was restricting him of 25 miles. And then the court established that these two are, in fact, abusive. Why? Because they're over the reasonable amount that we consider in Quebec law. So there were injunctions on two grounds. So is there an injunction with regards to preventing Lambert from working in the photocopying industry? The court ruled no. Why? It's too restrictive. Lambert has a right to earn a living. And then the court asked, do they have a non-competition clause that is restrictive? They ruled, so do we grant an injunction? In other words, with regards to the client list used? Yes, was the answer to that. And that alone, Emmanuel, is the summary of Copyfax versus Lambert. So 2 grounds for injunctions. The only one that was granted was for the client list, okay? So that is proprietary information that belongs to the company. That, you can call it a trade secret. As well, yes?
So in the beginning of the conclusion, it says interlocutory injunction.
Right.
Until they make a decision, meaning interlocutory.
So if you do recall from chapter 4, I'm not sure if you guys looked at it, but it was course material. You have 3 forms of injunctions. It starts off with provisional only if it is emergency, okay? Urgent, right? Interlocutory is the one that is granted usually in cases with non-competition clauses. Okay, and then once the ruling is rendered, meaning the judge renders a final decision on the case, there is a permanent injunction that will or can be granted, and it lasts forever, in perpetuity. So interlocutory injunction is the only type of injunction granted. You're not going to be tested on interlocutory.
Okay.
Right? Just know what an injunction is, and it's pertaining to the Copyfax versus Lambert case. We have another question. Let me just try to come closer. Okay, so Annalena is asking, what is the difference between section 17 on the ALPI, so it's the Act Respecting Legal Publicity of Enterprises, and the section 16 of the QBCA. Also between some code articles and CBCA, some stay the same. Okay, I'm just going to erase. Emmanuel, was Copyfax versus Lambert clear? Just type in yes, that it's clear, so I can move on, unless you have further questions. Just assume. Okay, no problem. All right, so QBCA, you don't need to know for your final. You're not going to be asked specific articles. This is not that type of class. The acts to focus on in Chapter 6 are the Civil Code of Quebec and the Canada Business Corporations Act. But regarding the articles she was asking about, let's just keep in mind enterprise registration. First of all, according to Articles 17 and 19 of the ALPI, so the Act Respecting Legal Publicity of Enterprises, which is not exam material, I must emphasize on that, you have the obligation to register your enterprise. In other words, for enterprise, it is covered in Article 15, 25, paragraph 3 of the Civil Code of Quebec. Organized economic activity. So in short, one of the elements you need is a profit objective, okay? So you have the obligation to register with the enterprise registry because it's public record, okay? And that is actually one way you can see whether a potential business is legit or not, right? That's number one. Number two, 17 paragraph 3 talks about the following. The name cannot be obscene, right? So the whole purpose also is so that you register a name that is original to your enterprise, okay? So you cannot choose the Pellini Assassins, for example, as the name of your business. Its cause would be against public order, okay? Now, exceptions on who does not have to register. Number one, if you are using your legal name, okay, your full legal name as the business itself, you have no need to register. And according to Article 19, paragraph 3, I believe that's the article, 2 businesses, and this you don't need to know, it's not exam material. So tanning salons, as well as tobacco stores. These are the 2 others that do not have the need to register. Keep in mind, you're probably asking yourselves, Eddie, why do we need to register our business? It's not fair. Well, it's because it gives you rights, full rights to operate under that name. That's basically it. And if you care about jurisprudence, this is the jurisprudence in question. So it's based off 95 and 1938, and in 1958, I believe, the final decision was that usage of the business name is important. For those just joining in, type in your questions. I look forward to answering them. Keep in mind, I'm only here till 3:30, okay? Okay, let's see what other questions we have. Eddie, can you talk about the corporate veil? This seems to be one of the more popular questions, okay? Keep in mind, tonight, 6 to 10 p.m., we have a final consultation session, okay, where we do practice questions for your final tomorrow. So, let me just erase. Okay, so number one thing I always ask my students to do is refer to Article 309 in your book. In your book, there is a typo. Make sure you correct it. You can always Google what the actual article says. But I'll tell you, suppose this is how Article 309 looks in your book. I want you to cross a big line. And then you go to Article 307. 307 has 2 paragraphs. Next to 307, I want you to write 309. And that is actually what the actual article is. Article 309. If your professor gives you grief about it, tell them this is what the law actually says. Okay? So Article 309 talks about the distinction between the legal person's patrimony and the one operating it. Say the person's name is Jenny. Okay? And for all intents and purposes, I'm going to use the following corporation. Keep in mind, each party has their own patrimony. Okay? One of the primary reasons people incorporate their business is because of the existence of this corporate veil. Okay? The idea of the corporate veil is based off British common law in 1898, based on the jurisprudence Solomon versus Solomon. That's right, 2 brothers suing each other. Okay? So, let's remind ourselves what the word patrimony means. It's the assets and liabilities of the owner of that patrimony. Okay? According to Article 2, it's tied to an owner of the Civil Code. Article 2644 of the Civil Code stipulates that it has to have an economic value. Meaning, if Jenny has a patrimony and she only has liabilities, do you still have an economic value attached to it? I hope so, right? So it doesn't have necessarily a minus or negative. We think of that as business students, obviously. Okay, so that's number one. Number two, the corporate veil makes it so the patrimonies of each is distinct, it's separated. Okay? So corporate veil, it's Articles 309, 316, and 317 of the Civil Code of Quebec. This is always exam material, and one of the tricks law school professors play on students is the following, Article 316. So the question is usually like something like this. You have a corporate veil. Say Jenny is a director on the legal person's board of directors. Can you sue Jenny personally? The answer is no, because of the corporate veil. However, in the cases of fraudulent actions, say Jenny misrepresented a recent transaction totaling, I don't know, $2 million. You can go to the judge, say, Judge, Haboob, I want you to lift the corporate veil. I want you to lift it. You know how you lift a blanket? Same thing. Keep in mind, the corporate veil doesn't actually exist. It's not tangible. It's this abstract concept. Okay? That's FYI. So, Judge, I need you to lift the corporate veil so that we can sue Jenny personally. That is how you apply 316. That is one of the exceptions. Make sure you know it. Yes?
Okay, so it's good we went over it because I thought I wasn't sure if it was like one or the other. But I know it's both. So it's both separate entities, unless in the case of fraud, in the sense that you can't sue the director or whatever, right?
So only in the case of fraud, you can lift the corporate veil to sue Jenny in this case. Suppose she's the one committing fraudulent actions. Keep in mind, fraud means misrepresenting facts.
And in a case where the debt, would the corporate veil ever be lifted in like a case of just like intense debt, bankruptcy and all that?
No. It's one of the reasons it exists. So another way to explain 309, if 1432 blah 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 Inc. goes bankrupt, does it affect Jenny's credit rating? The answer is no.
There's no way.
Why? Because the corporate veil protects you from it. Okay?
I guess that's another reason why people like registering, right?
That's right. No, not registering, incorporating.
Incorporating, sorry.
Keep in mind, if you federally incorporate your business, you're automatically registered on the enterprise registration, which is called registry, right? It's public registry. You guys don't have any other questions? I feel like I'm doing all the work. Okay. So, another question. I'm going to skip that question. I'm going to go to the next person. Can you explain to me civil liability, how we can prove it? Yes, I can. How long do I have? Okay. I always start explaining this chapter by asking what is the difference between these two articles. Because it's just a Q&A, I'll just tell you. All right? So, 1458, they're very identical, especially their second paragraph. So 1458 is regarding contractual obligations. Now, in law, we use a prefix extra. Now, I know we're used to going, when we order fast food, let's say poutine, we go to the restaurant and we ask for extra cheese on our poutine. This does not mean the same thing. See, that means more of it. In law, when we talk about extra-contractual, it means outside of the realm of, the absence of contracts. So that's difference number one. Okay? Now let's move to the specifics. So the second paragraphs, in French we cite it differently. It's Article 1458, alinéa 2. In English, it is, you put in parentheses to notate a paragraph, okay? So, both have this in common. You can sue for damages. And for damages, I use the acronym VMN.
Because bodily material.
And moral, yes. So as your colleague just mentioned, it's bodily, material, and moral.
Yeah, learning.
You should know this stuff for tomorrow. It's the easy stuff. Okay? So you can sue under these domains, these realms of law. Now, are we good so far? People joining in YouTube, are you good? Oh. Okay. So I'm going to erase. So we're still stuck on 1457. So 1457, the first paragraph, notates or stipulates the following. 4 elements need to be met in order to prove in court a case of civil liability. Civil liability means civil responsibility also, as we just saw, extra-contractual liability. In fact, it's one domain in law that usually people don't like or don't seem to do well in law school, for example. Okay? So, number one, you ask the question, is the person committing the fault endowed with reason? This is not the same thing as is the person of age of majority, just like in contractual obligations. So keep in mind, in Quebec, the age of majority is
Quebec,
18.
security, right?
This article is not in your book, it's Article 153 of the Civil Code of Quebec. That's the age of majority. This does not apply to someone endowed with reason in extra-contractual liability. Extra-contractual liability endowed with reason is someone who is 7 and over. That's the distinction. Then we look at the fault. So when we talk about fault, you need to take into account, is there negligence? You don't say who's at fault. That's a wrong approach. In fact, law professors tell you in class. You look at, is there fault? Is there negligence? The word negligence means irresponsibility. Then, do you have damages? Keep in mind, BMM, bodily, moral, material. Bodily, material, moral in that order. Moral damages are those of psychological nature. In your chapter, you have stress and inconvenience, defamation, blah, blah, blah. And then last but not least, do we have a causality? And in law, for this chapter, we always go reverse. So we always say, did the victim suffer damages? Is there a fault based on negligence? Do we have the fault causing the damages, say, in a car accident? Do we have material damages caused by that person's negligence? Usually it's a yes. And finally, the person who's at fault, committing the fault, are they endowed with reason? Okay, that's how we do it. Do you have any questions?
You said something interesting, like a car accident. Is
Yes.
there like no fault?
So
Any
in-
negligence in Quebec?
In Quebec, we try to limit, but do you still have cases? I believe TVA just wrote an article a week ago. They said there's still over 1,000 cases, lawsuits over car accidents. Right? You do have automobile insurance for that reason. Okay, I have a bunch of questions.
When we're 1457, is it in the book now? I didn't find it.
Sorry?
1457, is that in the book?
It's the first article in chapter 8.
Chapter 8.
Okay. As one of the students asked the question, okay, I'll add more time for you guys, don't worry. Okay, this is my favorite case in chapter 7. Kabiakman versus Industrial Alliance. One of the things Industrial Alliance sells is life insurance. Okay, this case has nothing to do with life insurance. Number one thing you need to know before going in this case is the word extortion. I'm going to get to the real specifics so that we could move faster with the other questions. Seems like people are tuning in right now. Okay, so the word extortion in law means blackmail, right? So over here you have the plaintiff who was being criminally charged, okay? It's not the same as civil damages. So in civil court, you have a lawsuit and then you either win the damages against the other person you're suing or you don't get those damages awarded. In criminal court, you file criminal charges against the perpetrator, and then it is up to the police to investigate and move forward with actual criminal charges. They'll even consult you again and say, do you wish to keep going on with these charges? So there were criminal charges against Kabiak. Here's the part where I say time out. Do you remember what I said about non-competition clauses? So an employer has the right to protect its business image. And Kabiakman was a sales manager working for the company. Well, at the time, is still, okay? So Kabiakman is actually charged criminally, and the people managing the business, they're like, gee, we don't want a potential criminal in our business, in our midst. So we'll just suspend him administratively. And in Quebec, you usually suspend someone for administrative reasons if there's disciplinary reasons behind it. In this case, you don't have that. That's problem number one. Number two, they suspended the guy without any pay. The question the courts asked themselves during the legal reasoning phase, was he available to get paid? Meaning, does it infringe on his right to earn a living, right? In Quebec, that's a special thing they always consider. And so the criminal hearing occurred. He was not charged, convicted of extortion charges in the end, but that's irrelevant. The court's not going to look at that. The court's going to look, was the employee available to work during his suspension? And the court ruled, since the plaintiff at the time was available to work with pay, so he was available to work without pay, the decision was that they needed to suspend him with pay. That's it, that's all. So I repeat, they didn't pay him during his suspension. Because he was available to work, they told the company that they needed to suspend him with pay. Okay? What's the next question? Can you also give advice? Okay,
So he was suspended, and when he got back, he got those wages paid to him that were lost.
That's right. That's what he was suing for. Okay? That's all you need to know for this chapter. It goes further than that, but I mean, I'm not going to summarize 7 pages, right? So can you also give advice to manage the ethical case? You're worried about the ethical case. Annalena. The ethical case. So in your exam, you have 2 cases. I don't like calling them cases, first of all. They're essays. Okay? Unless, Annalena, you're referring to something else. Can you be more specific what you mean? Are you talking about the ethical essay you have to write? We'll just wait till we get a response.
There's no actual case.
I know. I'm just making sure of what she's asking. So I'm going to take the last question. Whoever types it first gets the last question. Okay. So keep in mind the last question. Annalena is saying yes. Okay, so I'm guessing she means ethical essay. So, people always forget this is not an argumentative essay, right? You need to have a legal analysis, however. And for the ethics chapter, it is not going to go outside the realm of what you have studied, looked at in your course. So say, for example, you're asked about a situation regarding child labor or corruption going on. You need to find a way to summarize all those notions into an essay. My recommendation, yesterday night we had the final mock exam session, right? We talked about this stuff. 1 idea per paragraph in your analysis phase, okay? Keep in mind, you always have to start talking about what the legal issue is, okay? So in an ethical case regarding child labor, should Canadian companies operate in Taiwan when there is child labor, for example? I put it very in layman's terms, right? And then you have to write about if there are any articles or laws that you need to mention. For corruption, there is the CFOPA, so the Foreign Officials Corruption Act, right? So in those cases, you need to mention that. Then you have to also talk about the notions of ethical principles. Keep in mind, whistleblowing should pop up in your question. Also, the United Nations Global Compact should be something you mention. Outside of that realm, you're not tested on, okay? I'm gonna take 1 final question. Who gets it? Oh, we only have 6 people. Going once, twice. Oh, someone texted. No, I'm not going to answer that question. Another question. If I see that you're asking a very specific question that the others don't need the answer to, I'm not going to answer. Right? All right, so I guess that's it. You have a question?
I think good.
Cool. Thank you everyone for joining us, and good luck on your finals. I'm going to be having a final consultation session tonight, 6 to 10 p.m. You just have to register on asaptutoringmontreal.com. And let me know how it goes tomorrow. You can always write us a message on our Facebook page or even on our website. Till next semester.